D.C. We turn now to a major rebuke of the Bush administration's spy program and what it could mean for state secrecy under the Obama White House. Last week, a federal judge ruled the National Security Agency's warrantless surveillance program was illegal. Chief Judge Vaughn Walker of the Federal District Court in San Francisco ruled the government illegally intercepted the phone calls of an Oregon-based Islamic charity called Al-Haraman in 2004. Both the Bush and Obama administrations had tried to dismiss the suit, claiming a trial could result in the release of state secrets, but Judge Walker rejected the state secrets argument, saying it presented, quote, obvious potential for governmental abuse and overreaching. The ruling marks the strongest legal repudiation to date of the Bush administration's spy program since it was first publicly revealed in 2005. Yesterday, I spoke to one of the attorneys representing the Islamic charity. I talked to the Portland-based attorney Stephen Goldberg. He talked to me from Oregon to explain what happened to Al-Haraman in 2004.
What happened to the charity was that after the National Security Agency warrantless wiretap program was instituted, conversations between directors at the charity who were outside of this country and lawyers representing the charity, primarily in the Washington, D.C. area, were intercepted. They had no idea that this was going on. All of this was secret until a document was disclosed inadvertently in 2004. That document, we believe, was evidence of the fact that these conversations had been wiretapped or surveyed by the government. When the document was first released, nobody really understood the meaning of the document. But then in December 2005, when the New York Times broke the story regarding the NSA warrantless surveillance program, suddenly people understood the meaning of the document. And ultimately, that document got to attorneys, and ultimately that was used as the basis for filing this lawsuit.
Can you tell us exactly what this document said?
I can't. The document is a top-secret classified document. It's also what's called an SCI document, a sensitive compartmented information document, which is a separate intelligence classification. And as such, we're not allowed to, even though the document, we've seen the document, we're not allowed in any way to discuss what the document says. To do so would be a violation of federal law.
Judge Walker's opinion cataloged other such evidence and declared that the plaintiffs had shown they were wiretapped in a manner that required a warrant. He said the government had failed to produce a warrant, so he granted summary judgment in favor of the plaintiffs. Can you talk about the other cases that he cited?
Right. Well, the conundrum that we had actually in this case was that we had this document. We believed that the document was evidence of the wiretapping that had been done of our clients, but we weren't able to use the document, and the government essentially has spent all the years of this litigation keeping us from using the document. Initially, they took the position that we couldn't use the document based upon the state secrets privilege, and that determination was upheld by the Ninth Circuit Court of Appeals. But the case was remanded back to Judge Walker to decide whether the Foreign Intelligence Surveillance Act, whether FISA, preempted or overcame the state secrets privilege. Judge Walker decided that indeed it did, and that we should be able to use the document in this case. But he then created all sorts of mechanisms for us to be able to do that. First of all, he said we had to prove that we had enough evidence to show that our clients were surveyed using non-classified evidence, which we were able to do. He then required or ordered the government to process security applications for the attorneys to allow us to basically have access to the government's classified filings in the context of this case. But at that stage, the government said they were unwilling to allow us, even though we got these security clearances, were still unwilling to allow us to use the document in the case. And at that point, Judge Walker said, well, the plaintiffs have done enough to present the evidence in the case. Government, it's now up to you to prove that, in fact, there was a warrant or that, in fact, they were not surveyed. And when the government failed to do that, failed to engage in that discussion in the case, Judge Walker concluded that we had presented enough of a case and that the government's actions were illegal under FISA.
Your co-counsel, John Eisenberg, said the Obama administration is as bad or worse than the Bush administration when it comes to these issues of invoking state secrets or justifying this wiretap.